coming before a court and telling me that. So you're lucky to be leaving today. You may leave. Thank you.
3 criminals at the bottom of the food chain, being schooled in the error of their ways by 2 very staunch judges in the American justice system. Pregnant women and children. Nations have gone to war over protecting them, and yet here we have who think they can do it and get away with it without consequences. Now, let's meet the consequence.
In summary, this indictment alleges that on or about August 30th, 2023, in Jefferson County, Texas, you committed the 3rd-degree felony of assault on a pregnant person. Well, that's terrible. That's terrible. You make it a practice of beating up on girls, or is that who you beat up on, or do you ever try men? But what do you think about beating up on a girl?
Looking good, sir.
No, it's about as low as it gets. It's like beating up on a child, isn't it?
Yes, sir.
Is that the kind of person you are?
No, sir.
The grand jury said you are. They indicted you for this. That's pretty low. Generally, people who pick on others, their gender and size, the ones who pick on others other than their gender and size, generally are cowards about picking on people who are their own gender and their size. Are you a coward?
Yes, sir.
Why would you assault a pregnant woman?
It was a misunderstanding, wasn't it?
Yes, sir.
Oh, you didn't know she was pregnant?
No, I knew.
Really? Well, there's 2 life forms there. Are you nodding? Does that mean yes? Can you speak English?
Yes, sir.
I see there's an agreement that's been reached where he would be pleading guilty to a lesser class A misdemeanor. Sell that to me, please, under these circumstances. I don't think it's morally right, but what do y'all want to say?
That's primarily based on my communication with the victim of this case, Judge.
And I've had similar communications, I believe, with the victim, although I did not overhear any of Mr. Ham's, but
She's
requested
the one that talked me into it, Judge.
she's been adamant that she didn't want to prosecute.
Well, that's not what probable cause affidavit says. Are you telling me at the time of the event, she insisted not to file?
Oh, no, sir. That's not where she was.
That's what you just said.
That was what she told me when we spoke over the telephone. Yes, Your Honor.
Okay, after he'd been in jail and had communications with her, which you're not supposed to have.
No, I didn't have no communication with her, sir.
Judge, I'm the one that's approved this agreement. The reason why I have is he doesn't show to have any record as far as that's concerned. This agreement with the conviction will allow, if he does anything further like this, it will result automatically in a felony, and it abides by the victim's wishes in this regard.
Well, all of us know what the statistics science shows in this type of behavior. Once you cross the line, you're capable of doing it, and you've shown a propensity, and that generally is women are vulnerable to this person. I just get the sense he couldn't care less. Get the sense that beating up on girls, pregnant women, are just the kind of thing that he does. What a thug. See, got into a verbal argument over a cell phone code. That's all it takes for you to beat up on a pregnant person, something meaningless like that. You punched her in the head with a closed fist, causing injury to her. Later, y'all began arguing again. You threw a multivitamin bottle at her leg, causing a bruise on her right leg. The agreement here is that you would be sentenced to 1 year in the county jail pursuant to the lesser included offense of Class A misdemeanor assault. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
And that is your child,
Yes, sir.
legally and morally. You should treat your child's mother decently.
And now, dirtbag number 2, who is trying his best to get his bond lowered, but obviously hasn't been in front of our Judge Stevens.
What are his bonds now, please?
It's like 60 and 10, Your Honor, 60 on the aggravated assault, 10,000 on the felon.
Who set those bonds? Curiously enough, I'd like to know. Because they're woefully inadequate under the circumstances that I'm looking at with prior criminal history and the facts of this case. Here, I'm reading the probable cause affidavit, which I'm sure would have been read, but let's see. Let's see. The victim says to the defendant, she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her, and hit her in her stomach. It was a revolver.
Right over here.
Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom underneath some clothes. It was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has 2 prior felony convictions. And these facts also resulted in him being indicted for aggravated assault, family violence. Anything else? What do you want to add from the state and then defense? Let me hear you.
I mean, Your Honor, again, like you said, I believe they were set way too low in this case. The state
What
would
do you
ask
ask
that on the assault with a deadly weapon, the state would ask for 150,000 and 50,000 on the felon in possession of firearm.
No, we would request a lower amount. We brought this to the attention. We've been in jail for almost a year now waiting.
I don't, so what's the point about that? Doesn't purge the facts.
No, it doesn't, but I was just, it's part of just the narrative to get to everything. It's just, I had to mention
Okay,
that.
narrate.
Your Honor, we have requested set on trial. It was set for, I believe, last week. We were on a trial docket. We did not get reached for trial. This is something we intend to try and get resolved. But in the
I
meantime.
want to ask this. Defendant is not eligible for probation, correct?
Yes, correct, Your Honor. Yes.
There's a gun in his home, right? And it has to match the firearm that was described by a complainant in another case. So let's talk about the circumstances of this case, if you want to or not. What do you say about the firearm?
Your Honor, it was found, it was not found on him. I would make the argument that it was not.
It was his home.
It was,
Who was he living with?
who was it?
I was in the room. It's not
But I mean, who lives there? It's not you. Other people live there.
it's not-
Who?
Or the victim.
The Vicks that they were there, they were there, so. But Your Honor, that's one of our arguments is that it wasn't found on his person. There's a whole issue about characteristic control.
Which doesn't need to be on this person, right?
No, but you still have,
Okay.
that's true. It doesn't have to be on the person, but you still have to prove the characteristic control. And there's gonna be some issues on that. Because it wasn't in his home by himself and there's some other arguments we're gonna make, but we'll make that a trial. It's not for here. But Your Honor, we just requested that we felt that this was too high, especially also we.
What about the assault of allegedly beating on a lady which is about as ungentlemanly as it gets. The court has little tolerance for a man doing that. Unless he's defending himself, of course, but I can't imagine the way I grew up. The way everybody should grow up, where ladies or should be treated like ladies. Those, I guess your story is she beat herself up to impress the police when they showed up. All right.
But Your Honor, his family has attempted to bond him out due to the fact that there is the multiple cases to bond out, and the amounts he has been unable to do that. Your Honor, he is from here. He has family here. He has relatives here. Everybody's here. He has connections to the area. He's not a flight risk. There's no doubt about that. So then it comes down to the big question people always point out, the dangers of society. This is a violent crime. We understand, but this is a targeted crime, but this is not a random crime of violence. This is something coming out of a relationship.
Well, I mean, it goes against the whole idea that our American society is built around a family unit. But somebody beating up, allegedly beating up on the female portion of the family unit is going to be apt to ruin that relationship and cause hostility. This, I think our moral nature is one of peace in the home, which this defendant is charged with completely and totally eradicating.
Your Honor, I think if the court would lower his bond, but add conditions in there of conditions are always in there, but no contact with the victim. Obviously, stress that if the court wanted to add a ankle monitor or some other monitoring device to help prevent that or to monitor that, what we would request that it's come down to a lower amount in the range of 20,000. I believe 60,000 based on these facts is high.
They're $100,000 in each case. These are atrocious, but his criminal history especially, he has no room for error. But to allegedly be beating on the family, a family member, and also being charged with a firearm, which has gotten him in trouble in the past. He's a felon, and that is disqualifying him from his privilege and right. And I don't find that to be unusual, unreasonable under this fact situation and his criminal history. Also, if he does post a bond, he must have, he will be placed on home confinement, not the victim's home or the complainant's home, some other place that you are going to live. And you must have a GPS and can only leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Is that what we're doing?
It's already been on the trial document.
Let's try to get this as soon as possible.
Yes, sir.
And the defendant is ineligible for probation.
Yes.
All right, so let's.
And now dirtbag number 3, who is about to see how some people can say a lot just by the way they look at you. The Simpson stare. It's legendary.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. All right, you understand that, sir?
Yes, sir.
All right. Now, you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea. What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No,
Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department Report 24, the injury to the child and the relationship and the statement from the report. And ask that that be admitted on the basis of.
Any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
Sir, the understanding is you wish to plead no contest?
yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
You understand that all the rights that I explained to you apply to a no contest? He's not around
Yes,
this
Your Honor.
child currently. And everything is exactly the same. It's just that you are pleading no contest. Probably the worst thing is you understand that. He told me
Yes, Your Honor.
something. So to that charge, how do you plead?
No contest.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
and so what's the status currently?
Each child is residing with Mr. Carlson under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes, and protective services thought it was still okay for him to be with me.
And I've got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face and coming before a court and telling me that. So you're lucky to be leaving today. You may leave.
Thank you.
Subscribe if you want to see more of the Simpson stare. It's one of those stares that says 3 words. And what are those words? Click on the episode on the screen now and find out.